Right. Welcome to Washington Legal Foundation's media briefing. My name is Glenn Lammy. I am Executive Director and Vice President of Legal Studies for Washington Legal Foundation. I want to thank you, those of you who are joining us live, and also if you're watching this on demand, thank you for joining us with that today. So WF started this kind of a program, a midterm briefing, around 30 years ago with the idea that we discuss both cases which the court had already heard argument in and written decisions in for the first half of the term, and then also discuss the cases that are coming up. We have plenty of cases to discuss in the not yet argued category, but just a single issued opinion, one that's beyond the scope of WLF's mission in the already written category. One has to wonder whether the justices and their clerks think they're back in law school again in their first semester, where they were waiting until Thanksgiving break to put together their study outlines for their final exams, or at least that's how this particular law student did it in his first semester. WLF filed amicus briefs in 6 cases that are still pending decision, as well as in the In re grand jury case that the court, unfortunately, at least from our perspective, dismissed as improvidently granted. We filed or will file in 4 more cases that are going to be argued in this part of the term. We also supported a number of certiorari petitions the court is set to address in the next couple of months, including one that's scheduled to be conferenced tomorrow, which is Johnson & Johnson versus California. If you want to learn more about that case, I've put a link to a blog post that I did for our Forbes.com site. It's a pretty important case involving unfair, deceptive acts and practices statutes, this one coming out of the California courts. So let me introduce our speakers first. Corbin Barthold is TechFreedom's Internet Policy Counsel and Director of Appellate Litigation. After doing clerkships with 2 federal district court judges, Corbin practiced law in Los Angeles at the law firm Brown, George & Ross. Before joining TechFreedom, he worked at Washington Legal Foundation as a senior litigation counsel. Jessica Ellsworth is a partner with Hogan Lovells, practicing in the firm's Washington, D.C. office. She focuses her practice on the Supreme Court and Court of Appeals. Just clerk for 6th Circuit Judge Martha Daughtry and Eastern District of Virginia Judge Rebecca Smith. Last but not least, Mark Perry is co-head of Weil, Gotshal, and Manges' appeals and strategic counseling practice, and a member of the firm's complex commercial litigation practice. He clerked for Justice Sandra Day O'Connor and 9th Circuit Judge Alex Kaczynski. So we are happy to take your questions today. If you want to type them into the Q&A tab at the bottom, just a reminder that this session is being recorded. So each speaker is going to give a few minutes just of opening remarks. So Corbin, if you want to go ahead with that.
Thank you so much, Glenn. It is a remarkable time in the law of internet speech. Of course, a litigant before the court recently wrote, the First Amendment applies with full force to websites. Cited for that proposition, the seminal case of Reno versus ACLU, cited in 1997. But a series of upcoming cases will put that proposition to the test. Last December, the court heard argument in a case called 303 Creative versus Alenis. The issue in that case is whether a website designer can be compelled to speak a message with which she disagrees in the form of being forced to design a website for a gay wedding. Then, pending before the court are cert petitions in the cases of Moody versus NetChoice and NetChoice versus Paxton. At issue in those cases is whether private social media platforms can be forced to disseminate messages they believe are dangerous, harmful, or abhorrent, or, on the contrary, do they have a right of editorial discretion over the speech they disseminate? Oral argument on February 21st in Gonzalez versus Google, the case that I will be focusing on most today. That is about Section 230 of the Telecommunications Act of 1996. Justice Scalia wrote The basic principles of freedom of speech and the press do not vary when a new and different medium of communication appears. Section 230 was enacted to honor that principle. With limited exceptions, Section 230C1 protects any provider or user of a platform, from large websites and apps to individual blogs and social media accounts, from liability for disseminating speech created by others. The issue in Gonzalez versus Google is whether that protection applies as a platform recommends content. Although I would reframe it slightly and say, is there a coherent way to distinguish recommendations from all of the other editorial activity that Section 230 clearly protects? Then the day after Gonzalez versus Google is heard, there will be oral argument in Twitter versus Tomnay. The issue in that case is whether websites expose themselves to liability when they provide routine business services in an ordinary manner. If you accuse them of simply not doing enough to scour their products for dangerous actors and removing them, does that expose them to liability under the Anti-Terrorism Act? So again, although my focus today will be Gonzalez versus Google, everyone should understand that in all kinds of ways, free speech on the internet hangs in the balance at the Supreme Court right now.
Thank you, Corbin. Jess?
Thanks very much, Glenn, and I appreciate the opportunity. This is the first panel that I've participated on with WLF, and I appreciate the chance to be here. Corbin laid out some of, I think, the more interesting substantive questions that are pending before the court and certainly generate a lot of interest. I think one of the more interesting things about this term is, in addition to the substance, we also have a really unusual situation where there has been an internal investigation that has gone on at the court. The court has been very slow relative to other terms in releasing opinions. And so I think the behind the scenes questions about what the court is debating internally about sort of its own role and the processes that it uses to get from the really interesting substantive questions to the really interesting substantive answers that all of us are eagerly waiting to hear. So I think that does make this term different from many terms in recent memory. There certainly are all the blockbuster cases that relate to, I think, the interest that WLF has. There are also blockbuster cases in many other areas of law. And it is, I think, hard to think of many terms other than this one that have had really such an array of truly interesting issues that that really everyone is fixated on. So I, like everyone else, am very eager for these decisions to start rolling out so we can figure out what some of the answers are to these questions.
Thank you, Jess. Mark?
Terrific. Well, thank you for having us, Glenn. You know, looking through the cases this term, one thing that struck me is there's something of a return to normalcy, by which I mean a lot of the pending cases are circuit splits over federal statutes, so the implementation of federal statutes that a national answer is needed. There are more business cases or business affecting cases than in some recent terms. More cases that sort of deal with the nuts and bolts of litigation and the intersection between federal law, usually sometimes state law, and you know, ongoing operations. That's not to say that the Supreme Court doesn't obviously have a great role to play in politics and life, but part of what we as lawyers need and what clients need and public interest law firms and everybody else is certainty. And I think that some of the cases this term do have the opportunity to provide more certainty. The other thing that struck me is perhaps, you know, we have a fewer number of cases. I haven't done the numbers, but the amicus brief pile seems to be getting bigger and bigger in all of them. You know, Gonzalez is an outlier because of the interest at stake, but even cases that in the past might have attracted one or two have 5 or 6, and it seems to me that there is an ever expanding play of the amicus briefs, which I think, you know, who knows what they think up there at the Supreme Court? Certainly not me, but it probably means there should be a flight to quality. If there are too many briefs to read, then some are going to get read more than others. I certainly think that the WLF briefs are in that category, predictably, substantive, but also not filed in every case, filed in those cases that have particular interests, and other groups, some follow that rule, some don't, but it's an interesting dynamic. So back to you.
Thanks, Mark. So we'll start off talking about the two cases that Corbin mentioned will be argued on consecutive days when the court returns next week. So many longtime Section 230 stakeholders were surprised, if not maybe dismayed, that the court granted a cert in Gonzalez. So Corbin, why did the court grant cert? Is there something about the facts of this case in particular that could signal its outcome?
Sure. The first thing to note in this case is, Mark mentioned the bread and butter of the Supreme Court when it comes to statutory interpretation is resolving circuit splits. We do not have a circuit split here. The question of whether algorithmic recommendations are special and outside of Section 230 protection has come up in the Second Circuit in a case called Force versus Facebook, and then it came up here in the Ninth Circuit. And in each case, the Court of Appeals said, no, this is just classic publisher behavior under Section 230. Section 230 applies as normal. No circuit has disagreed, and yet here we are with a grant. There were separate opinions below that disagreed with the majority opinions or said, we would have liked to have done it differently if it weren't for panel precedent binding us. But that's not a circuit split. Concurrences and dissents normally do not drive cert grants. So that is odd. That is noteworthy. Why did the Supreme Court take the case anyway? One possibility, there has never been a Section 230 case heard by the Supreme Court. This law is much discussed. It is controversial. It gets criticism from many directions. It could be a degree of simply we need to come in and finally have a word about this law. Putting that same point, but a little more strongly, there could be a desire among some of the justices to roll the law back for sort of the controversial reasons that have been attached to it, the big tech censorship complaints and stuff like that. Justice Thomas wrote a separate statement in a case called Malware Bytes a couple years ago, in which he raised sort of an assortment of qualms about how the law had been interpreted by the courts below. He accused the courts of sort of infusing the law with policy considerations that go beyond the text. I disagree with his arguments there, and so have all the courts below pretty much, but he's on the Supreme Court and they're not. So if he could round up a few other justices to hear the case for that reason, that could be why they took it here. Certainly some of Justice Thomas's issues that he raised have been picked up in some of the many amicus briefs on the side arguing for narrowing of Section 230. So that could be driving things. Now, you asked what might we try to read into how it will be decided. I have a suspicion that this case seemed attractive on the surface to anyone sort of interested in clipping the wings of Section 230 and then sending it back down to the lower courts, because you hear, oh, targeted recommendations, maybe we can kind of cut off a corner of the law and then send it back without, destroying it or something, causing a revolution. But if that's the attitude, I think the justices are quickly going to find that they are getting more than they bargained for, because as we see in the briefing, the petitioners have not been able to come up with a consistent position of where you would draw that line. They've shifted around. As Google writes in their brief, petitioners and the government offer no meaningful textual or technological distinction between the recommendations at issue here and the web's basic organizational tools. What's at issue here is YouTube having an up next video that will play next for you after the video that you're currently watching. And at the end of the day, no one's been able to make a clear line between why that is somehow different from a newspaper deciding what to put on page A1 versus what to put on page D6, which is clearly covered by Section 230, that kind of classic publisher activity. So I don't know. If anything, there might be a dismissal as improvidently granted as they discover how much more complicated this is than maybe they thought. Likely, I don't know, but very possible.
So moving on to the Twitter case, what are the main issues there? I think if the focus of the amicus briefs and the number of amicus briefs, the lower number in that case versus Google versus Gonzalez, this is far less of a tech case than Gonzalez, correct?
I don't know if I would say which one is more or less of a tech case, but I do think the fewer number of amicus briefs is suggestive of the fact that this case is not of existential importance to large platforms in the way that Gonzalez is. A loss here for the platforms would be expensive. It would be bad for content moderation, including for marginalized voices on the internet. But it wouldn't fundamentally alter the product the way that Gonzalez could. The issue here is the Anti-Terrorism Act was amended with a law called the Justice Against Sponsors of Terrorism Act. Section 233, did I get 3 threes? 3 threes, 2333D provides that in an ATA action for an injury arising from an act of international terrorism, liability can be asserted against a defendant who aids, I'll now quote, who aids and abets by knowingly providing substantial assistance or who conspires with the person who committed such an act of international terrorism, unquote. Now that's a mouthful, right? So we're arguing over the meaning of that. And one of the main issues is, does that provision require support for a specific act of terrorism, or is general support for an organization sufficient? The issue here being that there was ISIS content floating around on social media platforms before terrorist attacks. There's no connection where it's clear that the attacker was using that platform or there was recruitment going on. There's no real proximate cause here. So can you still sue and achieve, get secondary liability all the same? Well, if you parse that statutory language that I just read, the phrase "the person" is the object of who conspires with, and the act connects to aids and abets. That's a mouthful. You'll really have to get the statutory language in front of you probably to see what I'm saying. It might have needed a comma in there, but the short of it is pretty clear. You need to support an act of terrorism. And there are other signs for this. The fact that aiding and abetting at common law, that connects to an act. You aid and abet an act, not a person generally. So that's one problem for the plaintiffs there. Another is that substantially support terrorism doesn't mean just providing a general business product and having it used by someone with nefarious intent. If that's the ruling, that's going to be of huge impact to businesses way beyond the platforms. For example, if you're Hertz Rent-A-Car, now you need to make sure that criminals, don't rent your car. A lot more in there, but those are the basics of it.
So are there going to be things that happen in the argument for Google versus Gonzalez that you think are going to influence the way that the advocates in the following days' arguments are going to present their arguments, or the justices are going to present their questions at all?
It's, I suppose that's possible. So the posture of the case is both Tomna and Gonzalez were decided in a common Ninth Circuit decision. The district court in Tomna just happened not to get to Section 230, resolved it under the ATA, and the Ninth Circuit, for reasons of its own, I suppose, they decided they weren't going to get into Section 230 in the first instance either. It is so obvious that Section 230 governs both cases that the plaintiffs in Tomna agreed that if the cert petition in Gonzalez were not granted, they would stipulate to dismissal of the case. So kind of everybody saw that Section 230 governs both cases, I guess, except the Ninth Circuit. Maybe that's putting it a little too sharply, but the point being, if you win in Gonzalez, then you don't get to the ATA claim. It is the substantive underlying claim that Section 230 protects you from getting to if you're the defendant. So I suppose if the oral argument looks like a slam dunk for Section 230, maybe you adjust your strategy. I mean, I would say, you play to win no matter what, but it's possible.
So in our amicus brief, in the Gonzalez case, we stated that if the court reverses the Ninth Circuit in Tomna, it should dismiss Gonzalez as improvidently granted or affirm per curiam, because Gonzalez could not prevail on its anti-terrorism claim. Do you see that as a possibility?
Of course, it's possible. Actually, some of the platforms have asked for the court to rule in Tomna in favor of them and then get rid of Gonzalez. I think, if anything, it's slightly more likely that the court will address Gonzalez and then get rid of Tomna. For reasons we've already explained, there's clearly interest in hearing that case. We know that Justice Thomas is interested in tackling Section 230. So maybe if you rule for the platforms in Gonzalez, you don't need to do Tomne. But I'd like to introduce a dark horse possibility here, because I already alluded to this a little bit. The Gonzalez petitioners, in their petition for cert, they presented the question as, does Section 230C1 immunize interactive computer services when they make targeted recommendations of information provided by another? They then changed the question presented in their opening brief. And then by the time they got to their reply, they wrote, quote, "The court should not undertake to fashion a special legal rule about recommendations as such." They have not been able to take a position and stick with it. I would predict that Justice Kagan at the argument, because she's always incisive about this, will maybe take the lead in saying, what do you want? And so it has been set up such that, the justices, if they wanted to, have ample grounds to say the posture of this case has changed. Dig, go home.
So before we move on to other cases, Jess, Mark, do you have any thoughts on either of these two cases that Corbin was talking about?
Sure. Just a very short thought, which is that what strikes me about both of these cases, particularly because of the Section 230 question, is that even though there is no circuit split, I mean, I can't think of a case that has had the potential to directly impact every person's daily life in the way that this case does, because it really is about how the internet can and will operate. And that's something, lots of court cases are about very esoteric questions or questions that have a really nuanced audience. But this is really unique, I think, in its ability for everyone to both understand it and for it to matter to everyone's daily life.
Thank you. Mark?
Real quick, the SGs, the Solicitor General's briefs, tend to have an outsized influence in Supreme Court cases, and the brief in Gonzalez, I would submit, is very much a wolf in sheep's clothing. It purports to be somewhat neutral. It says some things are covered by Section 230 and some things are not, to borrow Corbin's phrase, which I like. They try to cut off a corner, if you will. But the rule they actually propose, or the approach they actually propose, in just a few laconic sentences with no citations, no analysis, would frankly allow, or at least allow, litigation over liability for much of the activities that are involved in the commercial internet information economy. What is required to keep the information economy robust and open would be under fire under the Solicitor General's approach. I speak my own views only here, but frankly, that brief is an invitation to litigation. It's a deterrent to innovation, and it could be viewed, and by me is viewed, as a threat to freedom. But it looks very plain vanilla. It's not.
Great, thanks, Mark. So we're going to move from an issue like Section 230 that the court's not really heard in the past to one that they can't seem to get enough of, which is arbitration. An arbitration case set to be argued on March 21st, Coinbase versus Bielski, has, I think, some interesting appellate jurisdiction and judicial economy twists to it. Jess, what are the issues in this case, and why do you think it's important to those involved in civil litigation?
Sure. So this case is one of the few cases that can be simultaneously being litigated in the courts of appeals and in the Supreme Court, because I argued the Ninth Circuit piece of this just earlier this week, and was appreciative to Mark for the amicus brief that he did in that case, and to both Mark and to you, Glenn, for the amicus briefs you did in the Supreme Court case. This case is about what happens when a district court denies a motion to compel arbitration. The Federal Arbitration Act gives the right to take an immediate interlocutory appeal of that denial of the motion to compel arbitration. But what happens during the time period that interlocutory appeal is going forward? And the circuits were really divided over whether during that interlocutory appeal proceedings are stayed in the district court as a matter of course, whether they're stayed applying the kind of discretionary traditional stay factors, or if there should be some other way of handling this question. And so the Coinbase cert petition arose actually from two situations in which a district court denied a motion to compel arbitration. In the Ninth Circuit, the rule was that the traditional stay factors governed. So both district courts then denied a stay. In both cases, Coinbase asked the Ninth Circuit for a stay. The Ninth Circuit also declined to put a stay in place. At the center of this dispute is a 1982 case from the Supreme Court called Griggs versus Provident Consumer Discovery Company. And there, what the Supreme Court said was that an appeal divests the district court of its control over those aspects of a case involved in the appeal. And in the motion to compel arbitration context, it's a little bit unclear what the aspects of the case involved in the appeal are. So the courts of appeals were divided 6-3 about how Griggs applied to this question. And this is important because absent a stay, and as Coinbase knows firsthand from these two cases at issue, a defendant has to defend itself while the interlocutory appeal plays out, meaning participate in discovery, participate in potential class discovery, participate in motions practice, react to amended complaints. And in fact, a case could even go so far as to getting to trial. There was a Fifth Circuit case that only because of a very last minute stay was a trial avoided during the pendency of the interlocutory appeal. So I think it is important to understand both as a matter of judicial economy for the district courts, but also from a defendant's perspective of they really do lose a lot of the benefits of having arbitration if they're stuck litigating for some extended period of time while an appeal plays out. So that's the issue that is being teed up, and hopefully this one the court will weigh in, will resolve the circuit split. It won't affect everyone's lives, but it will affect certainly those defendants who are filing motions to compel arbitration.
As Jess mentioned, Mark, you worked on a brief for the chamber and the NFIB Small Business Legal Center. Any thoughts on the case in addition to what Jess had to say?
I mean, for 20 years and more, we've been watching a tennis match between the Supreme Court and the lower courts under the FAA, right? The Supreme Court says over and over again, arbitration agreements are to be enforced according to their terms. And the lower courts, disproportionately in California, say over and over again, well, we found a way not to enforce arbitration agreements according to their terms. And Congress has weighed in and said, when that happens, you get an appeal. And, the defendants actually win a lot of these appeals. Our brief shows empirically, they win a lot more arbitration appeals than standard civil appeals. Stands to reason, not only from the structure of the Arbitration Act, but from that fact in the world, that a stay is warranted while the appeal plays out, because otherwise the benefits of arbitration are lost. I think crystal balling is a hazardous activity, but I'm putting my chips on Jess and her team in this one.
Thank you, Mark. Corbin, anything to add on that?
You get these 60, 70-page briefs in the Supreme Court, and one thing I've always admired is Frank Easterbrook's ability to clarify in 1,500 words what it takes other people that long to discuss. In his treatment of the topic, he says whether the case should be litigated in the district court is the mirror image of the question presented on appeal. And that's a limpid explanation of what's going on here. He says continuation of proceedings in the district court largely defeats the point of the appeal and creates a risk of inconsistent handling of the case by two tribunals. And that seems to settle it to me.
Seems logical, right? In April, the justices will hear arguments in U.S. XRL Shut versus SuperValue, which is the court's second False Claims Act case this term. So, Mark, why should the thousands of businesses that contract with the federal government be especially interested in this case?
So it's interesting on a few levels. I mean, one is we have another situation of a circuit split resolution. The Congress amended the False Claims Act in '86 to expand upon, or to explain, if you will, the knowledge intent requirement necessary to hold somebody liable under the False Claims Act. It's probably the most detailed statutory explication of knowledge or intent I've ever looked at. I mean, usually these statutes say, you know, whoever knowingly does X shall be guilty, right? And this one now has a 3-part test with 2 sentences in each part and all this. And the lower court still don't know what it means. They've divided several ways, and the most important one being on objective versus subjective understanding of the defendant. Do you have to know, in essence, or is it relevant that you know that you're committing a fraud on the government, or that the acts you're undertaking are unlawful? You know, the plot twist, if you will, here is that the uncertainty is generated in significant part by one of the Supreme Court's own decisions, not in a False Claims Act case, but in a Fair Credit Reporting Act case called Safeco, in which the court basically adopted an objective standard for this. And so one side of the split has said, well, the Safeco reasoning applies equally to the False Claims Act, and therefore subjective intent is irrelevant. The other side of the split says, and I'm way oversimplifying, but, you know, Safeco was not a False Claims Act case, and we have this statutory description here, and subjective intent is enough. And, you know, if you want to even more oversimplify it, the plaintiffs and the government want to make it easier to win, and defendants and most in the business amici, including WLF, want to make it harder to win because of this subjective objective standard. You know, what we know for sure is it can't be a different rule in Ohio than in California than in New York. I mean, this is one of those things that really should be a uniform rule nationwide. The reply brief in support of the petition from the plaintiff, from the relator, you know, put it very nicely, right? If the Seventh Circuit got it right, then affirm, and if it got it wrong, then reverse, and they'll have a rule for everybody, and we will have that by the end of the term. This one, I don't know actually how it's going to come out, because the statutory provision is it's dense. Let's just put it that way, and gives a lot of options for the court to figure out how to apply it.
So similar to this case, the other False Claims Act case, the XRL Polanski case, also had a circuit split on a very significant issue. That is when under what circumstances and with what amount of process can the Justice Department dismiss a qui tam claim once they've already decided not to intervene. Which of those 2 decisions do you think is going to have a larger impact on businesses that are subject to false claims litigation and enforcement?
You know, they're both going to be important in the sense that they will set the rules for FCA litigation. The government dismissals, I mean, it's very important, but it's a minority of cases, right, where the government comes in. You know, to me, the intriguing thing about Polanski is it invited the court in certain respects to look at the qui tam structure and the ability of relators to bring cases and the government's role and so forth. And I thought the most fascinating thing about the oral argument was that not a single justice really seemed to want to look under the hood of the qui tam provisions, which are unusual in our law and don't function the way that the relationship between government and the private sector usually functions. And, you know, none of the parties, you know, really asked the right question, perhaps, but the court really seemed to be focused on what standard must the government show to secure a dismissal, rather than should private plaintiffs be pursuing these cases at all, which to me is the more interesting question, right? Is sort of bounty litigation under the authority of the federal government with very little control, if any, from the Justice Department. So, you know, stay tuned. I think there's probably more to be said on False Claims Act litigation, but we'll have some more certainty as to how they will actually proceed once these 2 cases are decided.
Jess, Corbin, any thoughts on this area or this particular case?
Yeah, just to comment quickly on the super value case, which I agree is likely to have a broader impact on False Claims Act litigation. It reminds me a lot of the Escobar case on materiality from a handful of years ago in the Supreme Court. And what I thought was most noteworthy then, and I wonder if it will happen again now, is that the court didn't accept either side's view. It really did chart its own course. It disagreed with what the government thought and the ways the government thought it would make it easier, but it also disagreed with what the defendants and the whole array of amici were arguing there, and really set what has become its own standard. And as Mark said, given the language that's available to it in the statute, given the context, I think there's a good likelihood that this may be another situation where 5 years from now, we're all talking about the super value standard, which wasn't anything that any of us anticipated it would be as the case got teed up.
Corbin?
I really enjoyed doing False Claims Act work with WLF, but I've departed from it, so I should hold my peace. Other than to say that Jessica suggesting an Escobar 2 type situation is very disturbing to me.
Arguments will be held in April, also in a case called Slack Technologies versus Pirani, which brings the court back to what's become a recurring area for it, which is private securities fraud litigation. Mark, can you tell us a little bit about that case?
Sure. So this is a really interesting case, in part because it arises under the 33 Act, which is the subject of significantly fewer Supreme Court decisions than the 34 Act, which is the normal fraud provision that plaintiffs sue under. The 33 Act provides some advantages, including a close to strict liability standard for false statements in registration statements, but with additional hurdles. The most significant being the plaintiff has to trace, to use the language of the cases, the securities purchased to the registration statement being challenged. And this tracing requirement, which goes back 50 years or so, has been a feature of Section 11 and Section 12 litigation, almost as long as the statute has been on the books. The issue comes up here in the Slack case because Slack decided to do, rather than a traditional IPO, a direct listing, which really, to again, way oversimplify things, means that registered and unregistered shares, lawfully unregistered shares, hit the exchange at the same time and were available for public purchase. And the plaintiff purchased the shares on the exchange after the initial offering, but cannot trace them to the registration statement because the plaintiff can't prove whether or not they were registered or unregistered when issued. A quirk, if you will, of the direct listing. Slack, when sued, made this point that tracing is required. The plaintiff admits they can't trace, and therefore we win. And one would have thought that would be the end of it, except we're in the Ninth Circuit. And the Ninth Circuit decided, in its infinite wisdom, that, in 1933, the Congress must not have ever foreseen this notion of a direct listing. And therefore, since the statute doesn't apply, we'll just make up our own rule and then say that in this circumstance, tracing is not required. The kind of legislation from the bench that has given, frankly, the Ninth Circuit a bad name in some quarters. The Supreme Court has granted review of that. In the absence of a direct conflict, there are some many implied conflicts. Tracing is required in every 33 case, but not this one. But it's actually the first direct listing case to hit the courts of appeals. My own guess is it's just so clearly wrong that they're gonna say that. It's hard to see the court affirming the Ninth Circuit's reasoning, and unless they're willing to get rid of the tracing requirement altogether, again, something that's found in the text and context of the statute and that has been accepted by every court, including at least dicta in Supreme Court cases for a long, long time, this one seems to likely to join the long list of cases in which the Supreme Court and the Ninth Circuit take a different view of the applicable law.
Thanks, Mark. So other than Tom, the cases we've discussed so far, WLF has filed amicus briefs in them authored by our fantastic attorneys in the litigation division here. And you can find those on our website if you're interested in taking a look at those. The last case we're going to discuss today is one that we did not file a brief in. It's a super heavyweight patent battle between two biopharmaceutical companies. Just the court granted review in Amgen versus Sanofi over the recommendations of the Solicitor General, which didn't think the case was cert-worthy. Why do you think that is, and what's that issue at stake in this kind of patent fight?
Thanks, Glenn. So you're right. As you said, the CVSG brief, the government argued both that the arguments lacked merit and that further review wasn't warranted for a host of other reasons, and the court took the case anyway. This is a case about the enablement standard, which is one of the requirements to have a valid patent. And the two parties in the case each had patents on an antibody that performed a particular function with respect to cholesterol receptors on the liver. And Amgen then went and actually got what's called a genus patent, which covers the whole genus of antibodies that perform this function. They tried the case twice. Both times the jury found that these claims were not invalid for lack of enablement. And after the second trial, Sanofi moved for judgment as a matter of law, saying that no reasonable jury could have found that this universe of antibodies who perform this function was knowable without undue experimentation. And that undue experimentation is sort of the key language for enablement. As the case came up and the Federal Circuit affirmed the grant of JMOL on this basis. As the case came up in the cert petition, the two questions that are set out are really whether this enablement issue is a question of fact, or if it's a question of law based on underlying factual findings. And this is a court that I think loves old cases. The cases that suggest it's a question of fact date back to 1822, 1846, and 1854. All of the more recent formulations have focused on it being a question of law because it is derived from the statutory language with underlying factual findings. So that's the first issue that's teed up is, should we be reviewing this really as a question of fact or law? And the second is what the role is of the full scope of the claims, because in a patent like this, where you do have not just a particular antibody that's covered, but a whole class of antibodies, does the undue experimentation relate to knowing what the full scope is, or is it to just knowing kind of how to figure out if a particular antibody can perform that function? And here everyone agrees there are millions of antibodies. You'd have to test them one by one to see if they have this function, and it would take a lot of time and effort to do that. The question is, does that matter? So here, I think the fact that the Supreme Court took this over the SG's recommendation not to, and recommendation that there was nothing wrong with the way the Federal Circuit had looked at this, is a pretty strong indication that the court may see it differently. I expect these old cases to play a very clear role in how the court says how 200 years later we should be thinking about enablement.
So the court takes probably 60% of its cases to reverse, according to statistics in the last couple of years, and that's definitely held true with the U.S. Court of Appeals for the Federal Circuit. Is there, like you said, doesn't sound like there's much of a reason to think that that's not going to be the case here, Jess?
I think that's right. I mean, reading the tea leaves when you have an SG brief saying that the court got it right, and there are some other reasons not to address that issue here. I think taking it is as strong an indicator as I've seen in cases that there's some segment of the court that thinks this was wrong.
Mark, you filed an amicus brief in this case for a group of small and medium biotech companies. I was really struck by the prevalence of briefs on each side of the V from pharmaceutical companies. There isn't a unifying sort of approach here that helps all versus others. What do you think about this case, generally speaking?
It's fascinating, for that reason and others. There are it's Titans versus Titans, right, on the top line. So that we start there, right? This isn't the little guy against the big guy or traditional plaintiffs against traditional defendants. It's giant pharmaceutical companies battling over very lucrative, very important, life-saving, life-enhancing therapies. Both, the petitioner and the respondent have both developed FDA-approved drugs that are on the market and are used to treat millions of people and help their lives. You've got in the amicus lineup, you've scrambled the usual suspects a little bit. It's not companies on one side and somebody else on the other side, right? It's big companies on both sides. It's small companies on both sides. It's law professors on both sides. This issue has riven the community. Some of that due to economic interests and companies' own patent portfolios or patent litigation defense profiles. Some of it due to doctrinal views on this. You know, I'll register a mild dissent, I guess, from Jess's comment on the CVSG in this respect. At the petition stage, Amgen made a very effective presentation that the Federal Circuit's decision would harm innovation. That's sort of the policy pitch for review, while offering, you know, criticisms of the way the Federal Circuit got there under the enablement standard. You know, at the petition stage, there's an opposition brief, but, you know, as often happens, there aren't really amicus briefs supporting the opposition, right? Because, you know, so one side of that story was told. I think the merits case here is fascinating. If you read all the merits briefs, merits amicus briefs, you've got an innovation story on both sides, right? You've got the question of which rule. First, what is the rule? And second, how should the rule be applied? And then how would it affect innovation? So the court now has a fuller perspective in front of it, and I think may well you know, be thinking twice about it. I also think here is an area where the government's brief and the government filed solidly on the side of the respondents on the merits, right? After urging the court not to take the case, came in and filed a very strong brief that this is an invalid patent, which has, you know, really two significant things. First, this is the same government that issued the patent. So they're now saying that having reviewed it in light of all that's happened, it's not a valid patent. Second, the enablement standard applies in prosecution as well as in litigation. So, you know, the PTO actually is the experts on how, whether or not it's workable and so forth. And the government has a fairly straightforward explication that the Federal Circuit's, you know, established rule here is workable both at the prosecution stage and at litigation. So I think this one, you know, it's going to be a nail biter, frankly, for those involved in this industry, for those involved in the patent world, for those watching the Supreme Court. This is like, you know, it's Super Bowl Sunday for a small subset of the population.
And invariably, like all patent cases that get to the Supreme Court, it'll create more work for lawyers. At least in your business, can't be a bad thing. There is another really interesting intellectual property case before the court that involves, of all things, Jack Daniels and a dog toy. It's a fascinating case with some interesting implications for trademarks and potentially the First Amendment. WLF's going to do a preview program on that oral argument close to the argument time in March. So if everybody's interested in that case, we'll be getting an invitation out for that soon. So I wanted to give each of you a chance to talk about certiorari petitions that are pending that our viewers should pay attention to. Corbin, I know you've got a couple to discuss, one that's gotten a good amount of attention, another that's a little bit more under the radar. So I can go ahead.
Mark, I agree with him that viewed through a certain lens, Gonzalez versus Google might be seen as a wolf in sheep's clothing. So the petitioner's lead argument is, you know, Section 230 protects a platform as it produces the traditional functions of a publisher, what to put up, what to take down, what to emphasize. And the petitioners say, no. Publisher in Section 230 should be construed as that term was derived or used in defamation law. An element of defamation law is that there's publication to a third party. So under this like technical meaning, you're protected when you like convey information to a third party the way that that element was in like derived from defamation law and not otherwise. Your eyes may be glazing over from that, and it sounds maybe kind of innocuous, and yet it could basically gut Section 230. The social media speech codes coming up to the Supreme Court that I mentioned at the outset in the net choice cases, this wolf comes as a wolf. These laws just flat out say social media platforms have to carry all kinds of speech under basically any circumstances. So there's SB 7072 that's in Florida, and there's HB 20 in Texas. They're similar laws. I'll just pick HB 20 because it's a little cleaner in explaining what it does. It says social media platforms, the large ones, cannot discriminate based on viewpoint in content moderation, which is a really sweeping thing to say. You know, what that means is if you allow a health campaign by a government authority saying, if you're suffering from anorexia, go here to get help, you probably have to carry people saying, you know, here's how to be a better anorexic. And trust me, that's a distasteful example. It gets worse from there. I mean, it's as bad as you can imagine in terms of what that would require you to carry if applied in its full, you know, plain meaning. Nonetheless, the Fifth Circuit tried to undo a preliminary injunction of HB 20. The Supreme Court then stayed that attempt. So it's not in effect right now, but it's going up. The 11th Circuit affirmed a preliminary injunction of SB 7072. So we have a existential issue for internet speech with a square circuit split that is now in front of the Supreme Court. I see and I've never said this, I don't think, about a Supreme Court cert petition. You know, you never say never of these things. I see no way they duck this case. That said, they have played for time. They called for the views of the Solicitor General. So we'll see what the SG has to say. My guess, total speculation, is that they will squarely denounce HB 20 and SB 7072 while inadvisedly, in my opinion, trying to leave room open like, oh, well, those are bad, but, you know, maybe some kind of social media regulation could happen sort of coming from the progressive direction. We saw this with them in 303 Creative, where they invoked Rumsfeld versus Fair and tried to make this speech versus conduct distinction and play cute so they can win in that case by using the exact same playbook that the Fifth Circuit used to champion HB 20. So there's some sort of it's kind of a minefield. All of these cases are interlocking in ways that could blow up in people's faces as they kind of like try to win one if they're not paying attention to the other. It's Daphne Keller called it like one of those 3D wooden puzzles where you've got to get all the pieces to fit. So we'll see how that goes. That's something to look out for, by the way, in the Gonzalez versus Google argument is how much are the justices working through that. So that's a huge petition. And then just very briefly, I will mention as my own little pet issue, there's a really interesting cert petition in a case called Moore versus United States coming up. Issue there under the Fourth Amendment. Do the police need a warrant to engage in 24/7 camera surveillance of the outside of a house? And the Fourth Amendment and technology is creating all kinds of interesting issues these days. There is a business angle, both if you provide camera technology, obviously you're going to be interested in this, but the third party doctrine is going to have to get back to the Supreme Court, and we're going to need to hear more about this. And it's not quite related to Moore, but these are all sort of a piece. You're a business and you get subpoenaed by the government for documents. How does the Fourth Amendment govern, or at all, you know, your obligations in responding? Look out either in Moore or in cases coming forward. We're due for some interesting Fourth Amendment cases as they relate to corporate obligations.
Thanks, Corbin. TechFreedom was kind enough to invite WLF to join its amicus brief in support of review in the 11th Circuit case. And Corbin lays out a fantastic argument in that brief of why the court should take this case and reconsider the way that it reviews compelled speech in commercial settings. So that throws an even more interesting sort of angle into that case as well. And
yes, thank you. I should clarify, the 11th Circuit affirmed most of the preliminary injunction. And yes, the transparency issues are a whole nother chunk. So a lot of moving pieces in those cases as well, yes.
Jess, Mark, do you have any cert petitions you'd like to highlight?
Thanks, Glenn. The one I want to highlight is actually one that is being filed next week. And I want to highlight it because some of you, like me, may have forgotten that there was a clause in our Constitution known as the tonnage clause And it is a cert petition that is going to focus on that. And the tonnage clause forbids states without Congress's consent from levying revenue-raising fees on ships that use their ports. So then Congress in a statute said states can impose fees to fund waterway improvement projects with some restrictions. And in connection with a $1 billion modernization project, as soon as the first $20 million piece of it was completed, one of the ports in Texas began charging user fees based on the entire $1 billion modernization project. And the Fifth Circuit upheld that, saying as long as any piece of this project was completed, they can charge fees. So this case, I think, has some doctrinal interest because there's been increasing, I think, skepticism about the Commerce Clause and exactly what role the Commerce Clause plays in protecting free trade and international and national commerce. And the tonnage clause is a different way at getting of some of those same protections. So we think this is a petition that may have some appeal, and we'll be excited to share it with anyone who wants to see it once it gets filed next week.
Thanks, Jess. Mark?
You know, the one that caught my eye, I just looked over the pending ones. Stephen Donziger is this lawyer who got in a bit of trouble for some shenanigans involving Chevron litigation, which has generated, you know, more Second Circuit and Southern District opinions than probably any other single case. But there is a petition now in front of the Supreme Court that doesn't really have to do with the merits, but really goes to some very interesting and important questions under the separation of powers doctrine, specifically whether a court can appoint private lawyers to prosecute a criminal contempt action against a citizen who's under injunction. And it basically asks for the overruling of a 1987 case in which Justice Brennan and Justice Scalia disagreed on this very question. Justice Brennan had the majority at the time. Justice Scalia wrote a very powerful dissent explaining that the separation of powers and the Appointments Clause did not permit this outcome. You know, with the composition of the court and its approach to both the Appointments Clause and the separation of powers have changed significantly in the intervening 35 years, and you know, this could well be another example of a Scalia vindication, you know, after the fact. In this area, or they could let it go and decide it doesn't need to be decided. But it is interesting intellectually and quite well presented in the petition as far as just a matter of the contours and structure of federal law and the Constitution, which is something that the Supreme Court obviously is interested in. So that would be my contribution for today.
And that'll be an interesting situation if the court takes that one, because the underlying facts and that are like movie worthy. The whole Donziger and Chevron and Ecuador is really quite remarkable to follow. We followed that here at WLF quite closely, and it was going on. So if anybody has any questions, again, please type them into the Q&A box. I'll ask one real quick if nobody else has any. I mentioned at the outset, the court has a grand total of 1 written opinion so far this term. So what effect will needing to release 50 opinions in around 4 months have on the justices, not to mention their clerks? I'll throw that at anybody who has thoughts on that.
You know, there's a long time. It's only February. I mean, it's 50 opinions, but you know, it used to be there was always 50 opinions left in February, but they just decided 50 or 60 before then. Now they have decided none, but they only have 50 left. So I mean, they can do it. They've done it historically. What's interesting about it though is you know, as you all know, the sort of 9-0 decisions tend to trickle out at the beginning of the term, and then you can start striking cases off your watch list based on author and so forth. And for the bingo game, the Supreme Court watching bingo game of who's going to author which opinion and so forth, it makes it a lot harder, right? When you don't have as many data points. So I think it's really it's going to make the prediction game a bit harder, but I have every confidence they will get them all done by the end of the term, as they do every year.
Corbin?
Yeah, no matter how late they go, they always seem to come out with the high quality that we expect of Supreme Court opinions. I'm always expecting at the end of June that they're going to start coming out ridden with like typos and stuff or like bad mistakes. Nope, it's the Supreme Court. They get it done. Unfortunately, perhaps, based on the news last year, we know they're circulating drafts. They're going back and forth. But Mark is clearly the authority on this in the room. So my question for him is, will the clerks, they have to write a play as well, right? For the end of the term. And so
all kinds of things they have to do.
Jess, any concluding thoughts on that or anything else?
Yeah, I think I share what I think I read into or heard in Mark's comments, which is that I have wondered if it's a sign that there are just going to be fewer 9-0 or perhaps no 9-0 decisions from the cases that have been argued, certainly the early ones in the term. And so we're going to see a lot of concurrences and dissents, and we'll have to sift through the added challenges of figuring out how they factor into the rules that we're all taking away and telling our clients about afterwards.
Should have also asked what effect is it going to have on the poor Supreme Court media that has to cover all of these, some of which are joining us today. And I wish them all the best of luck. And I'm sure anybody on this panel would be happy to provide their insights to those reporters and make their job a little bit easier when it comes time to write those reports on the opinions. But seeing that there's no questions from the online audience, I wanted to thank everyone for joining us today. And thanks very much to our speakers. It's going to be a really interesting 4 months to come. And WLF will be very active in assessing and talking about these kinds of cases that are coming down. So keep an eye on our website. And again, thanks very much for joining us today, everyone.
Thank you.
Thank you, Glenn.